resources that IARMJ has produced. One which is actually on the Asylum Procedures Directive, and the other on vulnerability, which has just become available. They're freely available electronically. Well, the main reason for my title is that, like many national judicial systems in member states, yours in the Czech Republic and in Slovakia have been happily going along, applying your own procedural rules with your regional courts and your Supreme Administrative Court, incorporating as you have gone along principles from the ECHR and from international law in a gradualist way with your own refined case law. But then in July 2015, removal bans turned up. And national judiciaries in the member states involved in EU asylum law were all told that we now have to move to Article 46 3 Street, where we now live. There's now some Court of Justice guidance and some national case law, but there are still gaps. You can see I'll leave there a slide with the main cases, certainly that deal with Article 46.3, and they include the two very recent cases of LH and PG. LH was a Syrian national of Kurdish ethnicity who had been the subject of an inadmissibility decision in Hungary, and PG was someone who had a substantive decision. He was an Iraqi national of Kurdish ethnicity, and his decision had been twice annulled by the determining authority in Hungary. And can I just mention as well that in addition to Jakub Kundra, I owe a lot for my own understanding of the Asylum Procedures Directive to your very own Advocate General, Michal Bobek. And if at the end of my talk you feel you're lost, then all you need to do is go and read his Advocate General opinion in the case of Terubarov, and all will be rectified. You may, some of you recall Terubarov because he was a Russian businessman who managed to find his way to the Czech Republic. You extradited him to Russia, but he got out again and ended up in Hungary, and that was the beginning of his story in terms of the reference. So my PowerPoint is divided into four main bits. First of all, I'm going to talk about the genesis of Article 46 briefly, then its main components, and then focus in on the ex nunc requirement, and finally to try and tackle a few questions that arise. So turning first to the genesis of Article 46, well, just go back to that, I think, for the moment. The main, well, you'll know that throughout the member states, our national judicial systems vary a lot. In the terminology used by Advocate General Bobek in Terubarov, he talked about the alteration and cassation models, two ends of a spectrum, and their ideal types, but alteration is really where the court or tribunal has full merits powers. It can substitute its own decision. It can amend the decision. It steps into the shoes of the determining authority. It can order that its decisions be executed, and it can grant international protection. At the other end of the spectrum, we have the cassation model, where the court is confined to a mere review of legality. It can only annul. It cannot order anything about execution. But the important thing from the point of view of EU law is that wherever along this spectrum the national system lies, a lot is left by EU law to national autonomy. and this is the well-known principle of procedural autonomy, and that is the default position. And so in Advocate General Bobek's words, absent any specific EU legislative steps, courts and tribunals do their own thing, subject to the dual requirements of equivalence and effectiveness. And equivalence, as you know, is really the prohibition on any less favorable procedural rules for actions involving EU law as compared with those applicable to similar domestic actions. And effectiveness is really a requirement that national procedural rules must not make it excessively difficult or impossible in practice to exercise the rights conferred by EU law. But numerous pressures led the EU legislator to decide to impose harmonizing criteria in this subject area. So the traditional analytical grid, where it was simply the principle of procedural autonomy, has been modified. And there have been two main drivers to those. I'll call them rule of law drivers and asylum-specific drivers. And just very briefly, because you'll be familiar with these, I'm sure, one driver has obviously been the Strasbourg jurisprudence, particularly on the right to an effective remedy. Another has been the evolving EU public law, which has been especially linked to Article 47 of the Charter and the right to effective remedy. And in the case law on Article 47, the court has developed the concept of what they call effective judicial protection, which they see as the essence of the rule of law.
Také prosazuje právo na efektivní soudní ochranu a to má potom různé komponenty, například princip rovnosti zbraní, princip na efektivní obhajobu.
Representative. And of course, Article 47 has direct effect. And there's also more specific to administrative law. The Court of Justice essentially sees the level of the determining authority as required to pursue certain standards through Article 41 on the right to good administration. But it has insisted that it's not enough to simply have good administration. There has to be a judicial level which ensures access to the judicial review of that determining authority's actions. And then we have the asylum-specific drivers, which, as I'm sure you'll all be aware, derive from the fact that despite the qualification directive, it was very clear that there continued to be widespread disparities in the ways that member states were rendering decisions, and there was a lot of delay and recycling of cases, subsequent applications and so forth, and also a lot of ping pong. So I want to talk about the main components of Article 46. Just very briefly, scope. All I want to say about scope is it covers basically every type of decision, including inadmissibility and manifestly unfounded decisions. In terms of the nature of the remedy, this is what I'm going to talk about in more detail. Article 46.3, there has to be at least one level, but can be just one level, of judicial instance that deals with facts and law and conducts a full and ex nunc examination. Then there are time limits. Well, the EU legislator did not set down specific time limits, but it did lay down a requirement of reasonableness in Article 46.4. And then Article 46 also deals with the right to remain, essentially to guarantee that there was a right to remain during appeal proceedings. So let's now turn to Article 46.3, and you can see at a glance that, like the rest of Article 46, the ticking clock is very much to the fore in Article 46, because you have the temporal modalities in terms of Articles 46.4 and time limits, but then within Article 46.3, you have this focus on ex nunc, which is clearly a break from the old traditional models where the focus was on the ex tunc legality of a decision, an historic decision, and that was all that the judicial review was concerned with. Well, what does ex nunc mean? The court has told us in Alheto and other cases that it's essentially about new evidence, taking into account the evidence which has come to light since the adoption of the decision of the determining authority. In itself, that's fairly neutral. It doesn't say what has to be done in terms of getting the new evidence, but it has to be a part of the examination. Well, what does full examination mean? Well, leaving the term examination aside for a second, the Court of Justice has said in Terubarov that the full examination really involves two things. First of all, the court has to take the new and the old evidence together. The old evidence, what was before the determining authority, together with the new evidence that has come with the grounds of appeal and any other exchanges between the parties. Secondly, it has to subject that body of evidence to a facts and law assessment, an examination, and in order to achieve a finding, an evaluation both of the law and the facts. So that explanation from the court reinforces the need not just to consider, but also to evaluate what you might call the post-decision of the determining authority evidence. Interestingly, the court has said in Terubarov, this includes evidence which could have been taken into account. So it extends to evidence that may have been in existence at the time of the asylum interview or prior to the decision, but was not made known. Now, the general position is that such evidence, that the court should be slow to accept it, but it's clear from Article 46.3 and from the court's jurisprudence, there's no formalistic exclusion of such evidence. And of course, that is going to be important as our IRJ judicial analysis on vulnerability emphasized in relation to vulnerable categories. Late submission of new facts can be justified, for example, where there's trauma that might lead an applicant not to have given details of their torture or sexual violence. So I want to now talk about the ex nunc requirement, and that comes back to the term the full examination, because if you just go back to there, the full examination is double-edged, because the court has seen that the wording makes clear that the court or tribunal is not necessarily required to play an alteration role, the end of the spectrum where the court has full power to do everything, because it says where applicable. And so in Terubarov, the court has said that where applicable underlines the fact that the court need not necessarily undertake a substantive examination of the need for international protection. So it all depends on the nature of the decision. Is it an admissibility-related decision, or is it a substantive decision? Now, in relation to inadmissibility decisions, the court has highlighted that even there, the ex nunc requirement has a kick, it said in the very recent LH case, that was the Syrian Kurdish ethnicity, who the Hungarian authorities had decided to return to Serbia, that even in this type of appeal, the court must nevertheless look ex nunc. And what that involved, I won't go into the details, but it said, okay, it's an admissibility decision, so the focus is on first country of asylum under Article 35, safe third country under Article 38. And so what the court has to look at is what was the evidence relating to that, and did the determining authority produce the documents and any factual evidence relevant to that. So what about substantive decisions? Obviously, if the national member state gives judges full alteration powers, if I can put it like that, then they can substitute their own decision. Article 46.3 does not stand in the way of that. But if that's not the national system, if it falls short of that alteration model in full, Article 46.3 does not embody a pure alteration model. Having said that, it's not far off, because what the court has said in Terubarov and Alheto and cases like that is that there is this duty on the court of giving what I've called there a binding assessment ruling. Or the way the court put it in Terubarov was to say that where the court of tribunal has available to it all the elements of fact and law necessary in that regard, it has the power to give a binding ruling following a full and ex nunc exhaustive and up-to-date examination. So there's this power to formulate mandatory guidance, and it's a wide power because it's not just confined to the facts. It also relates to the law and the legal assessment of those facts. And it's also, I think, very important to note that as a result, in particular, of the Court of Justice case law, Article 46.3 imposes duties both on the court and on the determining authority. So obviously, if the court decides to grant international protection, it has the power to do so. That's the end of it. But if for one reason or another, the court can only annul, or if it has an option to annul, then whatever the form, annulment, it must still be that the court has conducted and reached conclusions on the assessment of the application for international protection and the grounds or reasons for doing so. Well, the question might arise, what happens, I mentioned earlier, this ping pong scenario, which came up in the latest case of PG and also came up in Terubarov. And here, the court, the Luxembourg court said that the member state court has an additional obligation. It said that if the determining authority has had your decision and has ignored it or contradicted it, then, and I'll just read out these words, I haven't got a slide for it, but the court must, where its judgment, where national law does not provide it with any means of ensuring that its judgment is complied with, the court must amend that decision of the national authority and substitute its own decision by disapplying, if necessary, the national law that prohibits it from proceeding in that way. This is quite radical. It's calling for the disapplication of national law. I'll come back to that shortly, but just shifting now to the duties that lie on the determining authority. What the court has said here is that there must be this duty on the determining authority, because otherwise Article 46 and indeed the right to effective remedy under the Charter in Article 47 would be deprived of all their practical effect because the determining authority could just ignore the court. And so the court has essentially said there are several aspects to the duty on the determining authority. It's not a complete grid. There is still what Advocate General Bobeck called some legal space left for the determining authority. But it must, first of all, in good faith, comply with the court's assessment. So in Trubarov, or Advocate General Bobeck, I beg you, in his opinion, said, the determining authority cannot misuse the obligation so as to rely on elements that are, formally speaking, new, but that have no impact on the factual assessment in order to circumvent the limits of the previous judicial assessment. So the determining authority must not try and circumvent the decision of the court. And as regards execution, the court has drawn on, particularly the Strasbourg jurisprudence, about the need for a practical and effective remedy, and so that the determining authority has to execute the court's assessment. And finally, the determining authority has to do it speedily. No time limits were set, but the language is quite strong. The fastest possible processing of applications of that nature. So we're back to the ticking clock. So I just want to come to some questions arising. I'm trying to stick to the main planks of Article 46.3. That's for my own safety and security, because I do not know about the precise circumstances of the Czech system, or indeed of the Slovak system. Although I am aware that you have in the Czech Republic, certainly you have a very refined case law dealing with your procedural rules. So I'm really just sticking to the planks of Article 46.3 through the jurisprudence of the court. So you'll please forgive me if some of these questions don't affect you at all, but it might nevertheless be helpful to outline some of them. So the first is, what does Article 46.3 mean in terms of preparing for the hearing? Must the court be proactive? And I've raised that as a question because I think the way that the case law from the Court of Justice is evolving, it's moving towards saying that members of courts and tribunals must be more proactive. But I don't think they're saying to judges, do your own thing. I think what they're saying is that you must be proactive vis-a-vis the determining authority. So they're saying, if you recognize that there isn't enough evidence, for example, then you must take proactive steps to ensure that the determining authority gets it for you. So to take a paradigm case, supposing you have a vulnerable applicant, a trafficked minor, and you've got the file and the appellant's submissions, but it's clear to you that the COI about the country of return is inadequate. What do? I think the direction of travel of the court's jurisprudence is to say the judge must not sit on his or her hands, but will have to think about such steps as, for example, directing or ordering the determining authority to provide the missing evidence, the COI in particular, in time for the hearing. If necessary, to adjourn the hearing so that the determining authority can produce the COI and exchange it with the appellant. There would also be the option of the judge seeking the COI for himself or herself, but as I understand from some of the cases in the Czech Republic, that can be a difficult step, and because there are procedural requirements to make sure that the parties know what the evidence is on both sides to ensure equality of arms, for example. But I do think that that is the way that things are moving. So, and of course, to go back to the example of the trafficked minor, it may even mean, for example, if there are mental health issues, that the court has to consider asking the determining authority for an expert report, because there are other provisions in the Asylum Procedures Directive which talk about the need in certain circumstances for expert evidence. So I want to come to the next question. What should the court do when there is new evidence that the judge is aware of, but which had not been addressed by the parties, either in the decision or the grounds of appeal? Well, the court actually addressed this issue in a case called Ahmed Bekova. She was an Azerbaijani national, mother and child. Her husband had applied separately for asylum, but she and her child applied in their own right. And the presenting issue was whether she could raise a new ground not put before the determining authority. And the new ground was effectively that she'd made a complaint to the Strasbourg court, actually, that she'd been sexually harassed at the workplace, and that she was also involved in a media activity opposed to the government. Well, the court observed that when they looked at the file further, that she seemed to have actually raised these new grounds in some shape or form. So she was essentially asking to provide new evidence at the hearing. And what the court said was, and I'm just going to try and dig up the slide if I may, is that first of all, if someone is, well, they can raise new evidence so long as it is not too late in the day, so long as it's sufficiently specific, and so long as it's significantly distinct from the evidence that went before. So the answer seems to be that new evidence subject to those requirements can be considered. So I want to turn to the question, does the ex nunc requirement mean that the regional first instance court must consider new grounds? Well, that depends what one means by new grounds. If it means since the decision of the determining authority, the answer is absolutely clear. That's the logic of ex nunc. The new grounds are part of what is before the court or tribunal. They must be dealt with. But what if the new grounds are ones that were only made known at the hearing itself? Must the court consider these? And again, going back to Ahmed Bekova, what the court said there is that, well, if someone brings up a new ground at this late stage, it technically amounts to further representations under Article 41 of the APD recast. And the court was quite emphatic about this. In general, this is to be discouraged. Why? Because it would enable the appellant to circumvent the determining authority. It's the job of the determining authority to make the assessment, and indeed, it would also diminish the obligation on the appellant under Article 4 of the Qualification Directive to cooperate with the determining authority. So in general terms, new grounds are to be discouraged. But the court went on, nevertheless, the national court cannot wash its hands of the new ground or just refer it back, or not necessarily. And again, it comes back to these similar requirements that came up in Ahmed Bakova. So what the court is saying is that this can be done so long as it wasn't raised right at the last minute, so long as it is sufficiently specific, and so long as it's significantly, or at least distinct from the evidence that went before. So if those three conditions are met, then the court must get on with the job. Now, that may mean in this situation, it's a new ground, that what the court then has to do is to take what we in the UK would call interlocutory action. But what I'm talking about is the court would have to adjourn the case to ask the determining authority, your department, to give their response to these further representations. And this is what the court emphasized in Ahmed Bakova. So take the example of someone who, for the first time at a hearing, says, I'm a Christian convert. Then applying the logic of Ahmed Bakova, the court does not necessarily have to engage with that unless satisfied it wasn't raised right at the very last minute, that it was sufficiently specific and significantly distinct from the evidence before. But if that is the case, then the court must engage with it and as I say, adjourn so that the determining authority can tell the court what its response is. And so you can see from this that in doing that, the court is not getting rid of the case. It's not disposing of the case. It's simply adjourning it to get the determining authority to do something which it must then bring back to the court. So I want to go to the question, in appeals against refusals to grant international protection, a substantive decision, must the contents of the court's assessment ruling be comprehensive? You recall earlier we talked about the reference by the Court of Justice as this idea of a binding ruling from the court. Must it be comprehensive? Well, the court does talk a lot about the need for an exhaustive examination, but I don't think it implies a duty of comprehensivity. Article 46.3 is not a straitjacket, and the court has always been careful to highlight the fact that even though the new logic is that the court must try and complete the case, that does depend on there being a sufficient factual matrix. And there may be some elements that the court does not have. And that is why in this scenario, there may be need for further consideration by the determining authority. So coming to the last question, what is the status of the appellant's application for international protection when the court annuls or refers back? And here I think I think obvious, but probably worth saying in terms of the structure of Article 46.3 that if something is referred back to the determining authority, the application for international protection remains outstanding. It has thereafter to be processed by the strict criteria of good faith and execution of the decision speedily and so on. But it remains outstanding. So it would be wrong, for example, for the court or tribunal to say anything about a subsequent application. In any event, if there was a subsequent application, then the applicant wouldn't have any application for international protection at the time. So I'm going to stop there. I'm conscious, as I say, of not wanting to trespass on your national case law, and that is why I've stuck very much with the main planks of Article 46.3.